In this video, we will try to understand the recent debate on LGBTQ same sex marriage demand. We will try to understand the historical aspects of this topic, the current discrimination against the community, global scenario on this issue, further Supreme Court observations, then we will try to conclude with the way forward. RSS chief Mohan Bhagavat spoke on LGBT rights, saying Indian civilization has traditionally acknowledged the community. In an interview to RSS affiliated magazine Panchajanya, he spoke about a story in Bhagavatam that King Jarasandh had two generals, Hamsa and Dimbaka. They had some sort of relation, said by Mohan Bhagavat. It was supported by Professor Jawaharlal, who works in National Sanskrit College. He stated the words Sati Premi have been used to describe the relation between Hamsa and Dimbaka. Further, a 3rd century book or a 3rd century historical concept explained in Kama Sutra. In the book of Kama Sutra, Vatsayan wrote, people at that time had same sexual relations. There was an entire chapter dedicated to this particular aspect. And they used to practice parigraha, where two people of same gender cohabited for life. In medieval century, we have Sufi saint Samad Kashani, who fell in love with Abhay Chad. Unfortunately, both were executed by Aurangzeb after revealing this relation. I would like to tell there is a book in India written by Salim Kidwai and Ruth Vanita, Same Sex Love in India. Others argued that ancient Indian text, inscriptions, paintings on temple walls clearly highlighted homosexuality is not an alien concept to India or modern concept to India. I would like to tell you that when we were colonized by Europeans, that is British, they started to impose the Victorian notion of customary laws on India. Hence, they brought Section 377 IPC to regulate the unnatural offences in India. Now, we will try to understand what are the current discriminations faced by community. They were unable to access adoption rights. Even the recent Surrogacy Act excluded the community to access to surrogacy. They face discrimination in terms of getting the jobs. Even after getting the employment, they are discriminated in public offices and private offices. Their marriage was unrecognized. The Telangana's first gay marriage, Supriyo Mukherjee, he went to Supreme Court and applied that their marriage should get recognition under Special Marriage Act 1955. I would like to tell you that United Nations Human Rights Commission in one of its reports stated these people are denied for basic rights, for example, banking rights, insurance, healthcare. Feminist scholar V. Geeta in her findings wrote that this community is facing a lot of harassment, and as they are discriminated in several aspects, they even fell into the poverty. Now, these were the observations given by various scholars in India. Now we will try to understand the the global scenario on this aspect. We have Article 16 of Human Rights Declaration, which stated that people whoever residing in any country, they had a right to marry and right to found a family. This resolution highlighted that one should respect the LGBT community, and whatever human rights existed for the others, they must apply to this community. Then the European Council for Human Rights, in one of its observation, stated that LGBT community should have equal rights. In a case, Dudgeon versus UK in 1981, the European Court of Human Rights struck down offence of buggery in Northern Ireland, which is a violation of European Convention on Human Rights. South Africa also joined with the other countries along with USA in recognizing LGBT community rights, even the marriage and basic rights. As of now, 32 countries around the world have legalized same-sex marriages and offering them basic rights. To begin with, Netherlands is the first country which announced the legalization of same-sexual marriages in 2001. In this aspect, we will try to understand Indian context. In my opening remarks, I spoke about the historical context of the issue. Now I would like to bring you the Supreme Court observations on this issue. Anjali Gopalan, Madam, started one organization which is Naj Foundation to help the people who are suffering with HIV/AIDS disease. Unfortunately, when she launched this campaign, she came to know in 2001 a man who was involved in homosexual relation was severely discriminated by the people. She went to High Court of Delhi in the famous Naz Foundation versus Government of NCT 2009. And this case, Delhi High Court clearly stated that the homosexual relation between adults violating fundamental rights guaranteed by the Constitution. And this judgment created hope for the LGBT community, and they started to come out and they celebrated like anything. Unfortunately, in 2013, Supreme Court in Suresh Kumar Kaushal case reinstated section 377, but this was reviewed by the Supreme Court in several judgments. Now, after the Suresh Kumar Kaushal versus Union of India case, a review petition was filed before the Supreme Court under Article 137, and the case is Nelsa versus Union of India, where Supreme Court clearly stated that transgenders will have the rights of 14, 15, 19 and 21. And it also stated that 377 is anti-constitutional in the sense it doesn't stands with the constitutional aspects. Later, Puttaswamy judgment in 2017 supported the right to privacy as a fundamental right under Article 21 in a way supporting the private relations of LGBT community. But the interesting case which raised the demand of recognition of LGBT community was Shafeen Jahan versus Union of India. The case is also famously called as Hadia case. In this case, Article 21 was expanded to right to marry and also stated that the choice of partner, whether within the outside marriage, is exclusively domain of individuals. In a manner, Supreme Court supported that the society doesn't have any role or substantial role in choosing a partner or life partner. It was also supported by Supreme Court in Shakti Vahini versus Union of India case that the panchayats, that is Kap panchayats or community assemblies, so on and so forth, should not interfere in right to choosing a life partner, which is a fundamental right guaranteed under Article 21. But the most important judgment is Navatesh Johar versus Union of India, a petition which was filed against Kaushal judgment. As I told you, Kaushal judgment, that is Supreme Court reinstated Article 377. But in this Navatesh Johar versus Union of India case, Supreme Court struck down IPC section 377 and it provided that LGBT community are equal citizens and they cannot be discriminated in law based on their sexual orientation and gender. Supreme Court is very clear on this aspect that it is a high time to join with the modern communities to support them. Unfortunately, the society is still having certain doubts about this relations, and this relation is going to affect the samskaras. Even Solicitor General also mentioned that this type of relations is affect the samskara or the Indianness or Indian culture. I would like to bring the better way forward for this issue. Now, the idea of samskara is now almost declining in India. As we see, the rate of divorce was rising. So, the samskara idea is at a question within the marriage life. Marriage is now considered to be merely a status conferred by the law. And it was mentioned that now marriages are not considered as a divine by section of community, as we see the rate of divorce are rising. But unfortunately, the divinity of the marriage should be recognized by each and every one by respecting the status of marriage. So, I can tell you that the idea of samskara should not affiliated to LGBT community marriage. Any marriage is divine, we should respect it. Further, a section of Hindus will worship Lord Shiva in Ardhanarishvara form, respecting the divinity of the same sexual orientation or transgenders. So they should get respect from that aspect also. Supreme Court, in several judges which I referred in the previous slides, supported the constitutionality of the issue. So one should give basic respects to that community. Further, human rights commissions, UN bodies also supporting the element of LGBT community, and it is a symbol of mature democracy. Madras High Court, in several observations and in a famous case, clearly stated that it is a high time to sensitize the people on this issue. It advised to revamp medical education in India. Special training should be given for the people in public institutes, particularly the people of working in police offices. We should appreciate here Tamil Nadu government, which modified the code of conduct of police with respect to dealing with the code of conduct of police in dealing with this community aspects. It also advised that curriculum of MBBS should be revamped to understand this people issue in a better manner. They also said that the sensitization should also happen in schools, colleges, and universities to support this community. Government should give a status of recognition, as Supreme Court, one of the Supreme Court judge observed that Parliament should take the debate and discussion about this issue to have a better idea from the different communities of the India. Then United Nations Human Rights Commission stated fourfold strategy: protecting the community, preventing the harassment or bullying, prohibiting discrimination, and safeguarding the communities. I would like to end the discussion with a quotation given by former UN Secretary General Ban Ki-moon, that that is, the LGBT community people are entitled to get same rights as elsewhere. They too are born free, equal. So let us stand with them, support them, but regulation of conversion therapies should be the core of the core of the ruling, the core of the law in the society. As stated by Madras High Court, that India should not allow conversion therapies, but it is the time to recognize them as people with basic human rights. Thank you and Jai Hind.